Hi, I'm Ryan Cummings from the R&R Law Group. Welcome to Your Brother at Law. Here, we break down Arizona law into simple, straightforward terms. So whether you're looking for tips or insights into legal processes, I'm here to make the law easier to understand. So let's dive in and make legal knowledge more accessible to everyone. We have two questions today for Brother at Law, and they are kind of similar to one another. But the first one's going to be, what will happen at my arraignment? Now, your arraignment is your very first court date, the very first time you see a judge. Now, if you get arrested, it may be in the jail that you see the judge, or if you get cited and released, then you're going to see the judge at some time later, usually about 30 days away from the date that you get cited. Or if you get a summons in the mail, then you're going to get that arraignment date. An arraignment is simply a time for you to go in and either plead guilty or plead not guilty. Sometimes in the misdemeanor courts, there's a prosecutor there, and they may be offering you a plea deal at the front end of things, but most courts don't have that. It's only going to be you and the judge. And the judge is going to read you what you've been alleged to have committed. He's going to tell you the maximum penalties under the law. Generally, they'll tell you the minimum penalties under the law as well, and then they'll ask, how do you plead? And you plead guilty or you plead not guilty. Now, as a piece of general advice, we would always advise you to plead not guilty. The reason for that: go see what the police report says. See what evidence the state's going to have against you. See if the state's willing to dismiss some charges or do some plea negotiations. Now, best case scenario is you hire an attorney to take care of it for you. And what that means then is that if you hire our firm, we're going to enter our notice of appearance. On our notice of appearance, it's going to say we enter a plea of not guilty on our client's behalf. Why? Well, because again, clients don't hire us to go in and plead guilty right at the first setting. We want to be able to investigate the case. We want to be able to get the information that the state has, and we want to see what the case really looks like. Now, in felonies, the arraignment is going to take place in the Superior Court, and generally, the judge will only enter a not guilty plea on your behalf, and that's because stakes are a little bit higher. And in felony cases, you could get appointed an attorney, or you hire your own attorney, and then they're going to set that next case out. So that's what an arraignment is in a criminal case in Arizona. So as we go on to our next question, the next question is, will you be able to get this dismissed or when at my first court date? Okay. Again, that first court date being your arraignment or even your first pretrial conference. Could it happen? Yes, it is legally possible for us to get your case dismissed or win at that first court date. Is it probable? Unlikely. And the reason for it being is because usually by even the first pretrial conference, we don't have the police reports. We don't have the information that we need in order to be able to start tearing the case apart. That the rules say that the prosecutor, the state, has to provide your police report and your discovery by that first pretrial conference. So is it possible to go in and get it dismissed right at that first court date? It is possible, but it's pretty unlikely for that to be able to happen. So hope you found this helpful. Thanks for joining us today. If you found this video helpful, hit the like button and subscribe for more valuable insights. Got a legal question or topic that you're curious about? Drop a comment below and we'll consider it for our next video. If you or a loved one are facing criminal charges, give our office a call to schedule a free case evaluation. Your safety, clarity, and hope are our top priorities. Thanks again. We'll see you in the next video.